This past Friday, on July 19th, the International Court of Justice issued a highly anticipated advisory opinion on the legality of Israel's occupation of Palestinian territories. The court ruled, amongst other things, that for purposes of international humanitarian law, Israel belligerently occupies both the Gaza Strip and the West Bank, including East Jerusalem. And most importantly, it ruled that Israel's occupation is illegal and must be ended as rapidly as possible. Now, here to discuss this landmark decision with me is Professor Michael Lynk. Professor Lynk is Associate Professor at the Faculty of Law, Western University in London, Ontario. And he has taught courses in labor, human rights, disability, constitutional administrative law at the faculty. He served as Associate Dean of the faculty between 2008 and 2011. And most pertinently, for purposes of our discussion today, in March 2016, the UN Human Rights Council appointed Professor Lynk as the 7th Special Rapporteur for the human rights situation in the Palestinian territories occupied since 1967. And during his 6 years as Special Rapporteur, he regularly addressed the UN Human Rights Council in Geneva and the Third Committee of the UN General Assembly in New York. And his reports have been widely cited, and we're going to talk a little bit about some of those reports today. Thank you so much for joining me today, Michael.
Thank you very much for having me, Dimitri.
So, Michael, in November of 2017, in your second year of your term as the UN Human Rights Council Special Rapporteur for the Occupied Palestinian Territories, you issued what I would describe as an opinion, a legal opinion, that Israel's occupation was illegal at that point in time. 7 years later, the ICJ has, it seems to me, finally caught up with you. Now, before we get into the specific aspects of this decision, could you please give us an overview of what the court ruled on Friday? And also, if you could enlighten us as to how this decision goes beyond the ICJ's 2004 decision, which people rarely talk about in the public discourse in the West. This is 20 years ago. It ruled at that point in time that Israel's settlements and the separation wall in the occupied West Bank were illegal. So how does this decision go beyond that? And what do you think is most important and pertinent about this decision?
Sure. Let me provide a couple of features of to answer your question. First of all, let's be clear with respect to what the International Court of Justice is. It's the highest court in the United Nations system, and it addresses two different types of litigation. One is a state versus a state. So the January decision that the International Court of Justice heard and issued between South Africa and Israel, where South Africa has claimed that Israel is violating the Genocide Convention of 1948 in the conduct of its war on Gaza. That is a legally binding ruling because it is a state versus state matter. What we have in the ruling on Friday comes from a separate source, which is the other main feature of the ICJ's duties. It provides advisory opinions that are requested by competent organizations within the UN system. And in this case, in the very end of December 2022, the United Nations General Assembly asked the court for an advisory opinion as to what are the legal consequences arising from Israel's conduct of its occupation over the last 57 years, particularly with respect to discriminatory legislation, with respect to the denial of self-determination, and with respect to the question of annexation. And so that what the court issued on Friday was an advisory opinion going back to the General Assembly. This is non-legally binding, but these rulings tend to be very influential and precedent setting. And so I think this decision will be. So you've also asked me with respect to what did the court wind up saying. It ruled, as you said, that the occupation has become illegal and must be ended completely and as rapidly as possible. We knew as international lawyers and as those who pay attention to United Nations decisions, we knew for some time that there were many features of Israel's occupation, the construction and expansion of the settlements, the formal annexation of East Jerusalem, the many violations of Palestinian human rights, the construction of the wall in occupied territory. Those were illegal features of Israel's occupation. But we hadn't had a clear answer until now as to whether the occupation itself has become illegal. And that's the big difference between the 2004 ruling that was issued exactly 20 years ago in July 2004 by the court, which said that the construction of the wall in occupied Palestinian territory was illegal and that the settlements were illegal. So it had, if you like, a very narrow issue to decide 20 years ago. And obvious because Israel didn't obey the court's recommendation that it stop building the wall and then get rid of it, and also pay reparations and compensation to those who are harmed by the wall. So this led, I think, to a grassroots demand coming from civil society and eventually coming from the Palestinian Authority that the General Assembly should ask a new advisory opinion of the court, this time whether the occupation itself was illegal because of discriminatory legislation, because of the denial of self-determination, and because of Israel's both de jure and de facto annexation of Palestinian territory. And that's precisely what we received in its ruling on Friday, that the occupation is illegal and must be ended as rapidly as possible.
So just for the purposes of the non-lawyers listening to our discussion, I'd like to tie this back to this fundamental principle of international law, this prohibition against the acquisition of territory by conquest. The occupation began in 1967 in the context of a war which included Jordan. And as I understand it, at the point in time at which that war, just immediately prior to its occurrence, Jordan was in control of the West Bank. And as a result of the war, Israel came to control this territory. And at that point in time, the international community, right up until the current time, did not recognize this as part of the sovereign territory of Israel. So what you have for over 50 years is a military power, controlling territory by means of, as a result of military conflict, which does not belong to it under international law. And so am I correct in understanding this is really flies in the face of the notion of the prohibition against acquiring territory by means of conquest and the notion that occupations are meant to be temporary? Is that fair?
Exactly. You've put it very well, Dimitri, with respect to this. Rising out of the ashes of the Second World War, the world, at least the members of the United Nations at that time, in 1945, when they created the Charter of the United Nations, said right at the very beginning in Article 2.4 that members of the United Nations shall refrain from the threat or the use of force against the territorial integrity of any state. And that meant that now conquest and forcible annexation were no longer to be deemed to be legal. That was meant to try to eliminate the incentive for countries to go to war in order to expand their territory. Leap forward 22 years, as you said, in 1967, when the Security Council, in the aftermath of the June 1967 war, passed Resolution 242 in November of that year. And it said right at the very beginning, it talked about the inadmissibility of the acquisition of territory by force. And it's repeated that particular phrasing in, I believe, 8 subsequent Security Council resolutions through the years. And then finally, we should also point out a very famous decision from the International Court of Justice back in 1971 involving Namibia, when Namibia was being ruled by South Africa, and apartheid South Africa was attempting to actually annex Namibia as its 5th province and impose apartheid on the territory. This was a trust territory that the League of Nations had given to South Africa to rule. And then the court said in 1971 that so apartheid South Africa had no right to be able to try to annex what was a trust territory, that it had to govern that territory in good faith, in the best interest of the protected people living in Namibia. And it's that very same precedent analogy that a mandate territory and an occupied territory are trust territories that cannot be annexed or conquered, or where there's a sovereignty claim made by the occupying power. And that is I think the legal reasoning that lies at the heart of what the court said on Friday.
Now, in Ukraine, we know now that the Russian government's officially stated position is that for there to be peace, the Ukrainians are going to have to recognize that 4 of the oblasts in Ukraine, Zaporozhye, Kherson, Lugansk, and Donetsk, now belong to Russia. And the Western governments have consistently and emphatically taken the position, as has the Ukrainian government of Volodymyr Zelensky, that this would amount to an inadmissible acquisition of Ukrainian sovereign territory by force. My question to you, Michael, is, do you think there's any conceivable way to reconcile? I'm not talking about the rhetoric, I'm talking about the actual policies of Western governments, to reconcile how they have approached Russia's claim on those 4 oblasts, which have formed part of the Ukrainian state since the Soviet Union disintegrated in 1991, and their approach to the West Bank and Gaza. Can you reconcile these, the actual policies, not the rhetoric?
There isn't. There isn't any ability to reconcile them. The way in which the West, but particularly the United States, has dealt with the question of Israeli occupation, which has turned into annexation, which has turned into apartheid, shows that it has very little respect for international law. International law for it only applies when it's a cudgel to be able to bang away at its enemies, but not to be used when it may interfere with the illegalities of some of its allies. International law is not a menu a la carte. It's not something you can pick and choose. There's an entire integrated body of international law, particularly when it comes to international humanitarian law, international criminal law, international human rights law, that absolutely forbids the acquisition of even a square kilometer of territory under occupation. So what applies to Russia also applies to Israel as well. And we see this, if you like, double standards in the way in which the United States reacted over the weekend to the ruling of the International Court of Justice, where it said, they thought that the court was wrong to have answered this advisory opinion coming from the General Assembly, that the court's legal analysis of Israel's occupation was not worth much, and all it was going to do, the United States said, was drive the parties further apart. Nonsense. That's putting the world upside down. What you need to do is, first of all, establish what the clear legal principles are, and then you can wind up having principled negotiations between Israel and Palestine, where we negotiate over the modalities of Israel's complete withdrawal from East Jerusalem, the West Bank, and Gaza, the complete, evacuation of all of its 300 plus settlements in occupied territory, and then the recognition of genuine Palestinian self-determination.
And just to close out the discussion on this particular point, I invite you to comment. Would everything we've been saying about international law, the acquisition of territory by force, the temporal nature of occupations, would it apply equally to the Golan Heights, which were Syrian territory prior to and continue to be legally, as I understand it, Syrian territory since the War of 1967? Is it not the case that Israel has also violated international law by purporting to annex the Golan Heights?
And the United States has actually violated international law by recognizing Israel's annexation of the Golan Heights, which was done during the Trump administration and has not been undone by the Biden administration. So yes, Resolution 497 from December 1981, where the Security Council, including the United States, condemned Israel's unilateral annexation of occupied territory, the Golan Heights, and then there's been no resolution. There's been no resolution of that since, but that resolution has never been undone. It stands as good law today, and all of the reasoning used in the ICJ's advisory opinion released on Friday applies with equal force to Israel's annexation of the Golan Heights back in 1981.
Now, one of the things you did in your extraordinarily important tenure as the Special Rapporteur was you issued an opinion on the question of Israeli apartheid. As I recall, that was around, correct me if I'm wrong, it was around 2020.
2022 was my last report in March of 2022.
Okay. And you've mentioned it a couple of times in our conversation thus far. It does come up in the decision of the ICJ. It's not just you in your thoroughly, elaborated opinion on apartheid who came to that conclusion. It's also your predecessor, Richard Falk, former UN Special Rapporteur, B'Tselem, this wonderful human rights agency in Israel, Yesh Din, another wonderful human rights organization in Israel, Human Rights Watch, Amnesty International, and on and on. There is an abundant body of expert legal opinion that Israel is committing apartheid. Now, I've seen some suggestion in the public discourse that the court came to the conclusion that Israel is in fact committing apartheid. I read the decision yesterday. Certainly the court refers to this argument. What is your take on what the court had to say about that question?
Sure. I have two takes with respect to this. The first thing is to say that the majority did say that Israel is committing racial segregation and apartheid. It did it in a very soft voice, but it did it nevertheless. Keep in mind that the court's discussion with respect to discriminatory legislation, which is part of the questions that were put to the court by the General Assembly. The court devoted 49 paragraphs of its decision on Friday to discussing Israel's discriminatory legislation and measures in the occupied Palestinian territory. This is the largest single section of the ruling, and went on in great detail to look at the various forms of discrimination that Israel's practices and policies entail, including Israel's resident permit policy, its severe restrictions on Palestinian movement, and Israel's ubiquitous practice of property demolition, either as a punitive measure or as a response to the almost impossible to get lack of building permits with regards to this. So then the court then wound up doing an interesting thing, and this, I think, comes about because the court, probably the leadership of the court president, was trying to get enough consensus by a majority of the judges to be able to say something meaningful on discrimination and apartheid. The court, in its majority decision, specifically quoted in full Article 3 of the Convention on the Elimination of Racial Discrimination. And that provision, Article 3 says, and let me quote, "State parties particularly condemn racial segregation and apartheid and undertake to prevent, prohibit, and eradicate all practices of this nature in territories under their jurisdiction." And then the court went on to say, on that very next paragraph, it said that this article, Article 3, refers to two particularly severe forms of racial discrimination, racial segregation and apartheid, end of quote. And then the court went on to say, "We think for all the reasons we've expressed and all the evidence we've considered, that Israel's legislation and measures constitute a breach of Article 3 of the Convention for the Elimination of Racial Discrimination." Now, I think the best reading, in fact, I think the only reading of this concluding paragraph at the very end of the section on discrimination, is that the court has found that Israel is practicing both racial segregation and apartheid against the Palestinians under occupation. And while this delicate wording, I think, of this paragraph was almost certainly crafted in order to be able to bridge an agreement among a majority of the 15 judges on the court, I think the meaning of the paragraph, that Israel has imposed apartheid on the occupied Palestinian territory, yields no other reasonable interpretation. So that's, I think, the strong part. The weak part is I wish it had been clear with respect to this. And certainly we see in several of the separate concurring opinions by individual judges that they say in stronger terms that the court could have been clearer on this, particularly given the massive amount of evidence that they wound up laying out in the heart of this decision. But the long and the short of it is, I think it's absolutely fair to say the court found that both racial segregation and apartheid are being practiced by Israel in the OPT.
And I'm correct that the majority did include a number of Western-based judges or judges who come from Western countries, including Judge Nolte, the German judge. Is that
The
fair?
German judge, the American judge, the Australian judge among them. Yes, the judges who dissented, and they dissented on often pretty technical grounds, were, I believe, a French judge, a Romanian judge,
And the Ugandan judge.
Ugandan judge.
Mhm.
But the important part always is, what does the majority wind up saying? And if you want actually a better elaboration, go to the separate concurring opinion of Judge Salati, from a newly elected judge from South Africa, who is a very important legal scholar in the world. And this is one of his first times he's found his voice in the 6 months he's been on the court. And he says, the court could have been stronger on the issue of apartheid.
While we're on the subject of where these judges come from, and by the way, I harp on this a lot, because the Israel and its advocates in the West always talk about the bias, the hopeless bias of the non-Western world against Israel. But when these decisions are rendered, and this certainly happened in the case of the genocide provisional measures decision in January of this year, they don't mention the fact that a lot of these decisions are being supported by Western judges. They're coming from countries that are, whose governments are enthusiastic supporters of Israel. So that, bias argument doesn't really carry a lot of weight, I think, when you look at the actual composition of the majority. I mean, would you agree with that?
Oh, look, for sure. I mean, these 15 judges are elected from all around the world. They're elected by votes of the General Assembly, and they represent the diversity of legal systems, the diversity of legal cultures, and political cultures as well. And yet, we see a fairly strong majority. Of, at the very worst, the votes were 11-4. With respect to some of the provisions in this judgment. At other times, they were 14-1. So we have to take into account that the vast majority of judges have signed on to this, that there should be some credit given to the president of the court for ensuring that the language was as strong as it was, to attract as many of the judges to sign on with the majority. So this is our judgment. Believe me, I think it's going to resonate through the ages if we can get international law to actually wind up working for what it's supposed to be, which is to protect the vulnerable and the marginalized in this world.
And that takes me to my next question, Michael. The court had something to say about the obligations of other states in light of its conclusion that the occupation is illegal. What did it have to say? And in practical terms, what do you think that means for, let's say, to take an example, Canada's government? How is Canada's government required to respond, and other governments around the world, particularly those who have been supportive of Israel, to this ruling?
Sure. Well, let's see what the court wound up saying with regards to this. It said, after finding that the occupation is illegal and that Israel is under an obligation to bring the occupation to a complete end as rapidly as possible, that's its words. It said that, in its opinion, Israel has to evacuate all of the settlements and all of the settlers, 740,000 settlers from East Jerusalem and the West Bank. It then said that there has to be, Israel has an obligation to make reparations for the damages caused to Palestinians individually and Palestinians as a collectivity, as a people, concerned with respect to the occupied Palestinian territory. And then it said, which I thought was interesting, it said all states have an obligation, and this includes Canada, not to recognize as legal the situation arising from Israel's illegal presence or unlawful presence in the OPT, and not to render aid or assistance in maintaining the situation created by Israel's continued occupation. It then said the UN and all international organizations are under an obligation not to recognize as legal the situation in the occupied Palestinian territory. And finally, it went back to the General Assembly to say, you, General Assembly, it's your responsibility to come up with practical modalities, like practical action points that would be required to bring Israel's occupation to a complete end as rapidly as possible. So for Canada, as one example, what does that mean they have to be doing? Let me give you a couple of examples of what Canada has to do. And I think this obligation was on Canada even before this ruling came out. But now with this ruling, I think the obligation is even more pressing, and the spotlight is even hotter on Canada. First of all, Canada has a free trade agreement with Israel that allows settlement goods and products to enter into Canada tariff-free. Those settlement goods should not be entering into Canada tariff-free. They should not be entering into Canada, period. That would mean that the Canada-Israel Free Trade Agreement would have to be either scrapped or at the very least renegotiated such that it makes no application at all to the occupied Palestinian territory. Other countries who've negotiated free trade agreements with Israel, including, for example, South Korea, make it very clear that none of the free trade agreement applies to the Israeli settlements in the occupied territory. Second, there are a number of private organizations, many of whom have charitable status, who send money to Israel, and that winds up aiding and abetting the settlements. That has to stop immediately. Another adjacent example to that is the selling by Canadian real estate firms of properties in the settlements to Canadians in Canada. Those ought to be deemed to be illegal. Keep in mind, in fact, that the settlements are not only illegal under international law, as the court has reaffirmed, but they are actually a war crime, both under international law through the 1998 Rome Statute that created the International Criminal Court, but they're also a war crime under domestic Canadian law, because Canada in the year 2000 actually incorporated the Rome Statute and all of its lists of war crimes, crimes against humanity, and the crime of genocide into the Canadian Criminal Code. So it's our domestic legislation that says settlements are war crimes, and therefore that should be stopped. And that would mean then, probably taking a step further, that anybody strongly associated with the settlements is probably committing a war crime. That would include all present and past members of the Israeli political cabinet, Israeli military leaders, and certainly leaders of the settlements. They are not simply engaged in an illegality, which they should stop. They're engaged in a war crime, clearly defined in international and domestic law, for which, if they appear on Canadian soil, they should be arrested and tried under our war crimes legislation.
And just so people understand, Michael, how offside Canada is, as you know, back in 2017, I represented, or beginning in that year, I represented Dr. David Kattenberg, a wonderful human rights activist from the Winnipeg Jewish community, on the question of the labeling of wines made in Israel's illegal settlements in the West Bank. And they are labeled in Canada with the permission of the Canadian government as product of Israel. Dr. Kattenberg won before the federal court trial division, who said they were false, misleading, deceptive, these product of Israel labels. The government appealed. This was the government of Justin Trudeau. An appellate court sent it back to the Canadian Federal Food Inspection Agency for further elaboration. Yeah. And it has been mired there ever since. And we're still, 7 years later, we haven't resolved this question, which I would think is a no-brainer. It's a no-brainer, if you have any regard for international law at all, that the government would prohibit the use of product of Israel labels on products made in Israel's illegal settlements.
Yes.
Now, we don't need to get into that any further, Michael. What I really want to end our discussion today on is the question we're all currently grappling with more than any other, those of us who actually regard the Palestinian people as human beings who are equally deserving of the protections of international law. Do you yourself have an opinion on whether Israel is committing the crime of genocide in Gaza? And if so, what is that opinion?
I've seen what's been written with respect to the allegations of the crime of genocide, first and foremost by the application that South Africa brought in December and January of 2020, 324 to the International Court of Justice. It was a very persuasive document. I've seen the report in March of 2024 by my successor as Special Rapporteur, Francesca Albanese. Again, an exceptionally persuasive document. I've seen the reports that have been put out by a network of 5 human rights clinics at very prestigious law schools around the world, including Boston University, including a law school in South Africa, which have come to the conclusion that genocide is being committed. I've seen the work of the Lemkin Institute on Genocide Prevention, based in New York, which has concluded that Israel's committing genocide. And I think all of them have been solidly anchored on the examination of what the definition of genocide is in the 1948 Genocide Convention. I'm not an expert in genocide, but certainly my reading of all of these detailed analysis with respect to Israel's conduct of its war in Gaza has persuaded me that there is a genocide ongoing in Gaza. And if there is a genocide ongoing in Gaza, then the world has a responsibility to bring it to an end. We've seen on many occasions within our lifetime where genocides have occurred in Rwanda, in Serbia and Bosnia, indeed allegations of genocide being committed in Myanmar. And all of these instances, the Genocide Convention makes it very clear that this crime of crimes, this genocide has been described as, puts an extraordinary obligation on all other countries to do everything reasonable within their power to bring this to an end. And we've had these warning signals, these red lights flashing with respect to genocide since January, and yet we see, particularly with respect to the United States, but also with respect to Germany, continuing to supply arms, weapons, missiles, shells for tanks to Israel. Israel could not have conducted its war for more than a few days if the United States had brought both its diplomatic power to say end, this must end now, and decided to end all of its weapons trade to Israel. So not only does that place Israel as potentially committing genocide, for which its leaders must wind up answering when this question goes back to the International Court of Justice in a couple of years, it may well be that the United States should be answering this as well, because Article 3 of the Genocide Convention forbids complicity in genocide. And yet, if you continue to supply by diplomatic means, by finances, and by actual weaponry to a country or an armed force that is continuing to commit genocide, then you too wind up being equally responsible under international law.
And of course, Article 1 of the Genocide Convention obliges all states, including Canada as a signatory, to prevent genocide and to punish it
Yes.
as it occurs. So hopefully you and I will live to see the day when Canada takes those obligations seriously.
Well, let's hope that I intend to live a long life, so I'm looking forward to that day happening.
Me too. As always, Michael, it's a pleasure talking to you, and I look forward to having further discussions with you in the future as this tragedy in Palestine unfolds.
My pleasure, Dimitri. Thank you very much for having me.
And this is Dimitri Lascaris from Montreal, Canada on July 22nd, 2024.